Ladies and gentlemen, this is our contract changes regarding conveyances to foreign seller law webinar. And it is very important to us that we assembled here today for a very specific reason. Effective Saturday, this coming Saturday, July 1st, this new law will go into effect. This law is critical because it relates to the sale of some properties, certain properties to certain foreign buyers. This law is important to the real estate transaction because it imposes both civil and criminal penalties for noncompliance with the law. So again, a seriousness to what we're talking about today. The topic today, we are discussing this to promote compliance with this new law. It is as of Saturday, an important part of the real estate transaction, and we want to promote compliance. Now, our session today will go about an hour. We may or may not have time for questions. We hope to. You may have noticed that the chat is disabled. Having 6,000 of our favorite people chatting during a webinar, it would be a bit difficult to manage. So the Q&A function is enabled, however. So if you have questions, we certainly hope that you will submit those questions to us. Because as always, if we don't have time to answer them, we will certainly consider additional resources moving forward that may answer those questions for you. Things are still developing, folks. This is a new law. And so we're going to keep you posted as things develop, but understand today, this is much like the condo bill that we discussed, right? Today, we may not have all of your answers. And it is not for a lack of trying, it is a lack of legal certainty associated with this because it is a new concept. It is a new law. But it is not an unwillingness on our part to answer with specificity all of your questions. Just know we are still seeking answers to our questions. But please submit them to us. And as usual, we will certainly provide you the slides to your email sometime next week, maybe late next week given the holiday, but we will definitely get you the slides next week. But this webinar is not being recorded, so wanted to let you know that. Now let's get started. Our goal here today, and you'll hear me repeat myself quite a bit, and there's a reason for that because it is a difficult, kind of convoluted law. It is very nuanced, as we say here. And so I will repeat myself a lot for clarity purposes because it takes a little effort to digest all of this. So our primary focus here today is to explain changes to the Florida Realtor Florida Bar residential contract for sale and purchase and a number of other Florida Realtor contract forms that will change because of this law. But remember, it is a complicated piece of legislation. Why? Because this law restricts conveyances of Florida property to certain foreign principals, is how they're called in the law, foreign principals. It's pretty much buyers, but it's also owners, current owners, and potentially future owners. So this is why it is a complicated law. And it is also complicated because while there is nothing in, if you read the actual law, it does not reference real estate licensees at all. But you are a very vital part of the real estate transaction. And so you could find yourself running afoul of fair housing laws, depending on how you handle this transaction. And why is that? Because fair housing protects buyers from discrimination based on national origin. And as we get into the presentation, you'll understand why national origin is at least a consideration as it relates to this law. The other part of this is we're going to talk to you about some radiuses, we say certain properties. What properties? How do we know which properties we're talking about? Well, as we get into the law, we're going to explain that it depends on the property's proximity to certain types of properties or structures. And I want you to, as we talk about this, know that there is no searchable database as of yet with respect to these structures or types of properties that the subject property may be within proximity of. But we will get to that. There are also, I want you to keep in mind as we discuss this today, we're going to talk about things like a registration process and certain forms that will become a part of the transaction. And, there are no forms yet developed by the agencies under the law that are required to create these rules and these forms. So keep that in mind. Remember, this is developing every single day. And the other thing I want you to think about as we talk about some of the challenges is this is untested. This is new law. The concept is fairly new. And so there are no court decisions, and I highlight the word decisions yet, to help guide us on how this is going to impact you. So, this is not settled law in terms of how the Fair Housing Act and other laws apply directly to this new law in Florida. So keep that in mind as we talk about that. And, listen, this is information for your use. As realtor members, this is hopefully information that will give you some insights into this new law. I cannot emphasize enough. You've heard us say often, we want you to be the source of the information, not the source of the information. If ever there was a time when it is critical to the risk management ideas and principles of how you as real estate professionals conduct a transaction, it is now. This is a time where we are going to only be the source of the information. We are not going to be the source for customers on this, and you'll understand as we go through the law. Now I'm going to turn it over to Marcia, and she's going to get into a little bit more of what's going on with the forms. Marcia?
Good morning, everybody. So I have sort of the lighter lift today because what I'm talking to you about today is going to be the forms themselves. Let me start with referencing the Florida Realtor, Florida Bar as-is contract and the standard Florida Realtor, Florida Bar residential contract for sale and purchase. Those are the two forms that are used the most throughout the state and primarily still the as-is. Both of these forms are set to change. We have one revision that will be out Saturday, July 1st, because that's the effective date of the law, which includes brand new language. The language it's pretty short. It's contained in 2 paragraphs, and it is found on the last page of the contracts. It has been added to inform buyers and sellers that there is a new law that regulates and prohibits some sales to some foreign buyers. So there are no other changes to the form, okay? So when you look at the form, you will know you're using the latest. When you look at the footer, which is the bottom of the form, we've updated the revision date will be 7/1/2023, and the form numbers are going to be slightly adjusted. Currently, they are the as-is-6 and the Florida Realtor Florida Bar 6, and they're going to be updated to the 6Xs. Whenever you see an X on one of our forms, what that indicates to you is there has been a slight change, but not a wholesale comprehensive change to the form itself. Next slide, please, Joanna. In addition to those 2 forms changing, we have identical form changes also occurring on July 1st with 3 other Florida Realtor contracts for sale. That's the CRISP form, the vacant land contract, and the commercial contract. Next slide, please, Joanna. And lastly, we have one brand new form, which also contains the exact same language, okay? That new form is an addendum to contract, and it's going to be called Conveyances to Foreign Buyers Addendum. It's a standalone addendum, which you can use with an existing contract, which adds this new language to your contract if you so desire. Okay, next slide, please. Now, Joanna touched on this, but as she said, we're going to be talking sort of about the same thing over and over. Why are we here? We're here because during the 2023 legislative session, Florida's lawmakers passed a brand new law. It's Part 3 of Chapter 692 Florida statutes. It's called Conveyances to Foreign Entities. And as she said, the effective date is July 1st, 2023, which is Saturday. So when this bill passed and the governor signed it, we immediately began conversation about the impact of the bill and the contract. So one of my first calls was to the chair of the Realtor Attorney Committee, Lynette Hendricks, who said, we've got to have the conversation. I contacted the subcommittee chairs who deal with maintaining the contract, and that's Colleen Sachs and Julie Horskamp, both attorneys in Florida, and they willingly gathered the subcommittee. The first conversation the subcommittee had was, okay, what's this law about, and must we change the form? And in fact, they decided by the end of the first meeting, we are not required to change the form by the statute, but we want to change the form, okay? So sometimes when the legislature passes a new law, the law itself says this must appear in the contract. That was not the case here. But because this was a significant change to Florida law, the committee decided to consider what we needed to add. And after about 6-7 meetings, we ended up with a fairly limited revision that we're talking about today. So what we have are 2 new paragraphs that are being added to the very end of the form. You will find the language directly above the parties' signatures. Now, the reason I like to mention this is because many of you are a creature of habit. You know where provisions are in the contract that you refer to very often. Nothing has changed with regard to the order of the content. What is new is found again at the end of the form. The content is this: the language that's added informs the parties of the new law. In addition, it specifies that the buyer must provide an affidavit at time of purchase which complies with the law. The drafters also wanted to add some cautionary language. The drafters added that it is a crime to buy or knowingly sell property in violation of the law, and therefore parties should speak to counsel regarding their obligations and responsibilities. So again, that's sort of a description of what the change involves. But remember, this is a revision promoting notice about the law, but it is not language mandated by the law. Could you advance the slide, please, Joanna? So here is what the language is that you will be witnessing on July 1st. And I think many of you should have received the email we sent out yesterday, which contained the red line of the as-is contract. So you can actually see this language as it appears on the last page of that form. So we're going to talk about this now, and we're going to talk about it a little bit later after Joanna sort of gives you a foundation regarding the basis of the law. So those of you that have been, well, not yet, Joanna, I need to go back. So those of you that have been in the business for a while, you know, might notice that the very first line of this language is new for us to use, and it says, attention seller and buyer. And although Joanna said we're not making light of it, and I'm not, but it does kind of remind me of attention Kmart shoppers. But there's a point to this. The whole point is we want the parties to see this. So that's the first thing, attention seller and buyer. Then you'll go on and you'll look at the title of the new paragraphs, conveyances to foreign buyers. So what that does is red flag. If you are a foreign buyer, you need to be looking at this. If you are not a foreign buyer, it's not really going to apply to you. Okay. The committee went on and added specifically the sections of the law that specify the new law limits and regulates the sale, purchase, and ownership of certain Florida properties by certain buyers who are associated with a foreign country of concern. So right off the bat, the committee is adding language indicating this is a limitation on you foreign buyers. And then went on to specify the names of the countries that are foreign countries of concern. There was quite a bit of debate about naming those 7 countries. But ultimately, the committee felt it would be helpful, because if you are a buyer associated with one of these 7 countries, People's Republic of China, the Russian Federation, the Islamic Republic of Iran, the Democratic People's Republic of Korea, the Republic of Cuba, the Venezuelan regime of Nicolas Maduro, or the Syrian Arab Republic, you will know this applies to you. And conversely, if you are not associated with one of those countries, you will know this does not apply to you. Okay? Then you will look at the last sentence of this first paragraph, which is bolded. And it states, it is a crime to buy or knowingly sell property in violation of the act. This is uncommon, that ownership of property in Florida would constitute a crime. This is why it was added. This is why it's bolded. Now, going on to the next paragraph, you will see another sentence that's bolded. At time of purchase, buyer must provide a signed affidavit which complies with the requirements of the act. This is significant because this adds a document to closing. All right. Now, we're going to review this again, as I said, once Joanna talks about the law, but I just wanted to give you, sort of an idea of what you are looking at, what we need to digest today. So thank you. And Joanna, I'll turn it back over to you.
Thank you, Marcia. So you now have a kind of concept of where or how this will appear in the contract, when buyers and sellers will be put on notice of this. But I want to do a little bit of a deeper dive into the law changes and why. We need you to understand why the contract was amended as it was. This is general information. This is a snapshot of the current law. But again, the law is much longer than Part 3 of 692. It is a much broader law, but that's the part most relevant to the real estate transaction and the reason why we updated the contract. Now, I mentioned earlier, we have no court decisions on how this will be looked at or viewed from, legal circles. But I can tell you that there is one pending lawsuit that was filed a few weeks ago. And as of yesterday, the Department of Justice has entered the debate. The original lawsuit was filed by the ACLU on behalf of several plaintiffs and one real estate company directly impacted by the law. And the Department of Justice filed yesterday something called a statement of interest, reasserting some of the claims in the ACLU lawsuit, expressing concern about possible fair housing violations. And I think that's important because I want you all to understand that there are fair housing implications here. I have to be honest with you about that and help you understand that. They are also alleging things like impairment of contractual rights, civil rights, possible violations, equal protection clause, among other things. So, some of you have expressed similar concerns, and I just want you to understand that those issues are being litigated presently, and we will keep you posted on that status. But here's the thing about how you are going to handle the transaction. There is a feeling, right? When you first hear about this, there's a feeling, Juana, this is big, and this changes how we do things. And I want to be honest with you, in many ways, in terms of the tactical steps of conducting a transaction, it doesn't dramatically change what you do. Tactical steps. And because of that, we don't want you all editorializing any of this information because of potential fair housing implications. We are not in the business of asking people about national origin or where they're from and these types of things. And this is not a time to start, is my point. But try to, cut through the feelings about it and focus on the tactical steps of handling the transaction. NAR is assisting us in this effort. We're grateful for their help in trying to develop strategies. They are the experts on fair housing, and so we took it to the experts. And something we hear from folks all the time about the law is that, yes, there are other states that have either passed these laws or are considering it, but most of those deal specifically with agricultural land only, and there are no fair housing concerns when you are dealing with an agricultural land transaction. So let's get to the meat of it. The elements of the law limits and regulates the sale, purchase, acquisition, and ownership. Sale, purchase, acquisition, and ownership of certain Florida properties by certain buyers. Who are these buyers? Those associated with a country, a foreign country of concern. Marcia just covered those. They are defined in statute, not in the Part 3, but in another section of the statute. And it requires that buyers at the time of purchase, which the prevailing legal sentiment is, that means at closing, the time of purchase, to provide an affidavit verifying buyer is in compliance with the law. The actual law places the responsibility on the Florida Real Estate Commission to adopt rules to implement that section of the law and to adopt the actual affidavit. FREC, however, has not begun the process of rulemaking. So it is very possible that we may not see an affidavit from FREC for some time, but the industry is addressing that. And Marcia will talk about that a little bit more in just a minute. Now let's break it down. Again, I said certain buyers, certain properties. Now which buyers? So again, I'm going to repeat myself a bit because I want to drill down. The law defines something called foreign principles. Foreign principles. What's a foreign principle? These are individuals and entities, not just people, but also organizations, governments, and political parties. If they are associated with these 7 countries of concern, then they likely qualify as foreign principles subject to this new law. Now, what do I mean by associated with? Right? That's a very broad term. They give us some insight. The first is if the individual is domiciled in a foreign country of concern, right? And that person is not a lawful or permanent resident of the U.S. or U.S. citizen, so domiciled in one of the foreign countries of concern, not a citizen of the U.S., not a lawful permanent resident, they are likely going to be considered a foreign principal. Notice that the law says domiciled and not national origin. So people say, well, then is that really, what do they mean? They're fair housing considerations. Remember, with fair housing, you can have a direct, intentional violation of fair housing, the person's actual national origin, or you can have disparate impact, unintentional violations of fair housing if the practice impacts negatively persons of a particular national origin. So yes, it says domicile, but that doesn't alleviate the discussion about fair housing considerations. Who else can be associated such that they are considered a foreign principal? Well, a person or a collection of persons who have a controlling interest in a business entity that is formed for the purpose of owning property in Florida. So again, not just people, but also entities, persons who have controlling interest in those entities. You can be associated with a foreign country because you are a member of a political party or any subdivision of a political party of a country of concern. So political parties, that's a completely new concept in terms of ownership. And so this is why, again, you're not going to editorialize, you're not going to explain it, you're not going to try to help them understand what a subdivision of a political party in, some other country means. An official of the government of the foreign country of concern could be a foreign principal because they are associated. And then finally, entities with a principal place of business or a subsidiary in a country of concern could be considered a foreign principal. So imagine getting a transaction with someone who is purchasing in the name of a business entity, and you are now considering, do I need to try to determine ownership, where they operate, where their subsidiaries are? This is why we are telling you, you cannot be the source of this information. I really want you to understand how detailed even this definition of foreign principals can be, so that you don't find yourself in a position where you are assuming the need to find out all this information. It is very complicated stuff. So, we talked about the effective date being July 1st. Now, for the most part, this does impact or restrict foreign principals' abilities to be able to acquire property, but there are some exceptions. And so again, I want you to know this, not because you're going to go back and recite this to your customers, but I want you to know this because it is possible that someone from a country of foreign concern may qualify. Maybe if it is being acquired for diplomatic purposes, they can still acquire property after July 1st. Or if the foreign property principal has a de minimis interest, and they go on to define what that means. Listen, this is for your information, but again, this is complicated stuff. This is why I don't want you to get into the business of trying to figure out whether they qualify in an exemption. So now that's some general rules of the road. Here's the deal. The restrictions on the acquisition of property under Part 3 fall into three categories, three buckets as we call them. And so let's talk about what those are. The first is agricultural land. Now, what's covered when we talk about this bucket, this category? Well, we are talking about the fact that foreign principals cannot directly or indirectly purchase or acquire interest in agricultural land after 7/1. Unless they fall under exemption, they cannot purchase. And this applies to agricultural land as classified by the property appraiser's office. Now, if the agricultural land is owned before July 1st, so that's what happens after July 1st. Let's talk about the people who currently are associated with they're considered foreign principals based on the definition of statute, and they already own foreign property. They cannot acquire more. They cannot acquire more agricultural land, and this is a big component. We said the purchase, sale, or ownership or other acquisition. Those are the 4 categories. This is the ownership part of it. They already own it. They're not buying or selling. They already own it. They can't purchase more. And there is a registration requirement with the Department of Agricultural and Consumer Services. This registration requirement kicks in on January 1st, 2024. All right. But remember, there is no, I told you that at the beginning, there is no registration process in existence yet. Penalties for the violation. Failure to register, you'll hear this a lot. It subjects foreign principals to a civil penalty of $1,000 a day, and a lien may be placed against their property. If the agricultural land is acquired or owned in violation of the statute, that owner could face forfeiture of their property to the state of Florida. Forfeiture. So again, you don't want to try to figure out whether or not they have a responsibility to register, not register, can acquire, can't, because you don't want them coming back to you 3 years later saying, I lost my property because you told me that I didn't have to register. This is why you cannot be the source of this information. And then finally, a foreign principal who acquires in violation of this section, and a person. Now, person is not defined. It just says a person. They could have said a seller, but they said a person who knowingly sells commits a misdemeanor criminal offense. Now, that is who is covered under the first bucket and the possible penalties. Now, who's exempt? Well, exemptions apply to foreign principals with a de minimis indirect interest, or foreign principals who acquire the property by devise, security, interest, foreclosure, or debt collection after 7/1, aka inherited, right? I inherit this property after 7/1. Can I do that? Can I inherit the property if I'm a foreign principal? Yes, but you have to transfer your interest in that property within 3 years of acquiring it. Okay, so again, complicated stuff. If the foreign principal purchases for diplomatic purposes, then they can do that as well. But again, I cannot emphasize enough. You don't want to be trying to look at their operating agreement with their foreign company to determine if their interest is de minimis or indirect. You don't want to try to figure out, is this a inherited property? Is this something being acquired for the purpose of collecting debt under some judgment? You cannot put yourselves in that position. So stay away from that and allow the buyers and the sellers, or certainly in this instance, the buyers, to determine what their exemption may or may not be. Now, penalties, again, the property can be forfeited to the state, and any party involved or any person who knowingly sells faces criminal penalties. Now, second category. This one is a little bit more difficult to understand. This second group deals with properties located within 10 miles of a military installation or facility of critical infrastructure. What does that mean? Well, the prohibition says that foreign principals, okay, so always go back to this. We're talking about foreign principals. We say people can't buy, buyers can't buy. We're talking about foreign principals. The words matter. Cannot own directly or indirectly or acquire any interest in property located within 10 miles of a military installation. There are exceptions there too. We'll talk about that in a second. But the military installation pretty much means not just a base, but also a camp or a post or a station, a military yard or a military center of at least 10 contiguous acres. That is under the Department of Defense or its affiliates. There is no list that we have located that has a comprehensive list of all of these potentially impacted military bases, institutions, yards, centers here in Florida. So again, do not put yourself in a position of assessing that, okay? If the property is owned, so again, that was what happens. What happens after 7/1? But if before 7/1, the foreign principal owns the property, they again cannot acquire more. If they obtain it by devise, debt collection, foreclosure, all of those things, they have to dispose of it within 3 years, and they must register with, not Department of Agriculture, but with the Department of Economic Opportunity before December 31st, 2023, and registration will be considered late January 31st, 2024. So there is no registration presently. So same thing, penalties, $1,000 a day registration. A lien can be placed on the property. If land is located within that 10 miles of this military installation definition, it can be forfeited to the state. And again, there are possible misdemeanor violations associated with not complying with this law. Now, who is exempt? Again, you'll see similar things: de minimis and indirect interest, diplomatic purposes, those who acquire by devise, debt collection, all of those things. That after 7/1, but again, they have to dispose of it within 3 years, and they have to register with the Department of Economic Opportunity. It is important to note here that they refer to this as, in this section, this bucket, foreign principals is a person who purchases one residential property up to 2 acres. Okay, so they can actually purchase, this is an exemption, if it's up to 2 acres, if all of the following apply. Can't be within 5 miles of a military installation. Okay, so if it's within 10 miles, they can't do it. But if it's up to 2 acres within 5 miles of the installation, and the person has a current U.S. visa, the person, and that visa is not tourist based, and it authorizes them to live in Florida legally, and or that person has asylum, that's element number 2, and the named person on the transaction is the actual person who holds the visa, right? Those are the 3 elements that, if satisfied, a person, not an entity, not an LLC, not a corporation, but a person may purchase up to 2 acres if it's within 5 miles of the military institution, and all these other conditions are satisfied. Complicated stuff, folks. We are not going to try to figure that out for buyers and sellers, because again, the penalty, $1,000 a day registration penalty, forfeiture to the state, possible misdemeanor violation. Now, a little bit more about this bucket. I said military installation. There's also a category under bucket 2 that says these folks from these countries, the foreign principals from countries of concern, right? These are who we're talking about. Foreign principals from countries of concern. We're not going to say buyers. We're going to say foreign principals from countries of concern. They also cannot own or acquire interest within 10 miles of critical infrastructure facilities. If these critical infrastructure facilities have fences, barriers, or guard posts designed to exclude unauthorized persons, and they cannot purchase within 10 miles of that. Now, what is critical infrastructure? Very, very broad term. Refinery, manufacturing facilities, electrical power plants, water treatment facility, telecommunications, neutral switching offices, gas processing plants, all of these things, very complicated concepts. All of these things would qualify as critical infrastructure facility. And so if a foreign principal associated with a country of concern wants to purchase a property that they cannot, let me just say it like this, they cannot purchase a property within 10 miles of what is considered critical infrastructure. Much like there is no list of these military bases, installations, etc., there is no existing list of these types of critical infrastructure facilities. And, you know, it has often been said that the location of some of these are not widely disseminated because of the sensitive nature of what happens there. So just understand there is no list. We understand the difficulty associated with the fact that there is not one. We're not sure if one of the agencies will be creating a list. We are continuing that dialogue on a daily basis on your behalf. Now, I've kind of already talked about this, what's covered, so I'm going to move on to the exemptions. Same thing with critical infrastructure. If it's for diplomatic purpose, if there's a de minimis or indirect interest, if then they are exempt. Or if they acquire, but through those methods that we talked about after July 1st, again, they have to transfer the interest within 3 years, but they must register with the Department of Economic Opportunity within 30 days, of acquisition. There is yet no registry with the Department of Economic Opportunity. And so again, these persons could purchase, not entities, persons, one residential property up to 2 acres if all of those conditions that we talked about with military bases and installations apply. Can't be within 5 miles. They must have a current U.S. current visa that is not tourist based. They are legally authorized to be in Florida, or they have been granted asylum. Or the name that the person holds, remember that the name that the person of the person who is purchasing the property must be the same as the name on the visa or the other official documentation. Again, we've talked about the penalties. They remain the same there. Now, I want to get to bucket 3, People's Republic of China. What's covered? These are buyers associated with the People's Republic of China. They are domiciled in the People's Republic of China. They are not U.S. citizens. They are not lawful permanent residents or officials. But these are folks who are domiciled in China, or they are an official or a member of the People's Republic of China or the Chinese Communist Party. We do not want you to try to figure out people's political association. Do not ask those questions. Any person collecting or any person or collection of persons who have a controlling interest in a business entity that is formed for the purpose of owning property, real property in Florida, is considered associated with the People's Republic of China. So again, very similar stuff. I'm going to go through quickly for the sake of time. Their principal place of business or subsidiaries in the People's Republic of China. They are prohibited from purchasing or acquiring all property, with the exception of the exemptions that we have there. And if they own the property prior to January 1st, again, registration required through the Department of Economic Opportunity by December 31st, 2023. $1,000 a day civil penalty, subject to liens. If it's located within 5 miles of the military installation, and it is owned in violation of the statute, it can be forfeited. And again, anyone who knowingly sells or acquires in violation commits a misdemeanor offense. Now, there are some exceptions, same exceptions. I won't go through all of them because you've heard me say this. So for the sake of time, I'm going to move on. But I do want to point out the penalties for this particular section. A civil penalty of $1,000 a day or a lien. The property can be forfeited. Now, this section's different. It says a violation of the section of this law constitutes a felony, not a misdemeanor. A violation if you acquire it or own in contradiction to this law is a felony. But then it goes on to say that person who knowingly sells, right? Not the person who acquires, but the person who knowingly sells is committing a misdemeanor violation. Now, what about real estate professionals? I've covered most of this. There is no mention of the law for you specifically in this bill. FREC is mentioned for purposes of creating rules, including the affidavit. But note, the statute does not provide, the statute does provide that the failure to obtain or maintain the affidavit does not affect the insurability or the title of the property, and or it does not subject the closing agents to civil liability unless there is actual knowledge. So it uses this phrase, a person who knowingly sells, but remember, person is not defined. Is that just the seller? Because they could have said seller, but it says person. And so because it does not expressly exclude any particular categories under person, then we would recommend that you not be involved in knowingly selling this property. Now I'm going to turn it back over to Marcia.
Okay, so as promised, now we're going to talk about the changes in the contract again. With regard to the revision, as I said, it's 2 paragraphs. The revisions in the as is, in the standard Florida Realtor, Florida Bar Form, in the CRIS, in the commercial, and in the vacant land, and in that brand new standalone addendum are identical, okay? They are exactly the same. They are also in the exact same location in each of those documents. So the information is contained in 2 new paragraphs located on the last page of each of those documents, located directly above the party's signature. The committee purposely designed it this way in terms of the FAR bar to attract parties' attention. For the first time, the information has been framed in a box, and you'll see that in a minute. Wanted to let you know that the as-is residential contract and the CRIS contract both expanded by 1 additional page as a result of adding this language, okay? But that's all that changed. The content is the same in the rest of the document as it was before. Please note, there are no blanks to fill in the new language. There are no boxes to check. It is text for the parties to read. And lastly, again, the language of the revision was not actually mandated by the statute, but has been added to provide parties notice of the law. Again, the summary of the revision is this. It's a statement that Florida's law regulates and limits purchases by buyers associated with a country of concern, a foreign country of concern, and those countries are listed. It specifies that the buyer must provide an affidavit at time of purchase that complies with the law. It includes the reference that it is a crime to knowingly sell or buy in violation of the law, and parties are directed to seek legal advice. So overall, the concept is this. The idea of adding language to these forms was to make the parties aware that there is a new law and to get them to counsel to analyze their own responsibilities and obligations. So Joanna, could you please advance the slide?
Yes.
One more time. Okay, so this is a snapshot of what the revision looks like. So you see it's right above the signatures, framed in a box, with my attention, seller, and buyer at the very top. And again, if the committee could have put bells and whistles and lights, they would have, because this stuff is important. Okay, so we've kind of talked about, what is contained in the revision. One thing I want to sort of drill down on is the first sentence of the last paragraph in the box, which says, at time of purchase, buyer must provide a signed affidavit which complies with the requirements of the act. Okay, so we're going to talk about that, the affidavit. Joanna, could you please advance the slide? So, again, you have on the slide in front of you, it says buyers must provide an affidavit at time of purchase. So this is directly from the law, and the law requires that it be done under penalty of perjury. And this is what the affidavit is supposed to cover. That the buyer is not a foreign principal described in the law, or the buyer is a foreign principal that is authorized to purchase pursuant to the law, as Joanna just talked about some of the exceptions. And finally, that buyer is in compliance with the requirements of the new law. So the affidavit components are fairly simple. And if you think about it, it's going to simply be an additional document that has to be notarized as part of one of the documents that the buyer signs at closing. Okay, that's what this document is. One complication that we are faced with right now, as Joanna said, is the law specifies that FREC is to establish the affidavit by rule, and this has not yet been done. Okay, advance the slide, please, Joanna. So here's what we think is going to happen come July 1st and thereafter. So beginning July 1st, we think that buyers in all transactions will likely be given an affidavit from a closing agent which tracks the statute. But because FREC hasn't created that affidavit, the affidavits may vary somewhat depending upon who is generating them, who has created them. And that's okay. They have to track the statute, but there is no mandatory language at this point. Now, many of you have received copies of different versions of these affidavits that have been created by a variety of sources around the state. And we know this because some of you sent them to us, okay? So one of the ones that we were aware of is a set of documents that will be housed on Florida Land Title Association's website. And what they're going to have on their website are two different affidavits. One is for an individual buyer, the other for an entity buyer. Both conform with the requirements of the law that we just talked about on the previous slide. And both of these have a cover sheet, which is a notice with additional details that outline sort of in general the law that Joanna just described. And the reason that some of these affidavits may be accompanied by a notice is to assist the buyer understand the nature and content of the affidavit. So what I am telling you is this affidavit is a document that we believe buyers are going to receive from the closing agent. Once FREC establishes its rule and affidavit, we do not think this process is going to change. We believe this affidavit will be provided to buyers by the closing agent as a closing document. So from our perspective, right now, particularly in this interim period of time, when FREC has not created the affidavit, and we know there's going to be some variances in different notice cover sheets and affidavits, it seems to us that it would be better for the buyers to get that information directly from their closing agent. Because if you, for example, provided a copy of something you had received from closing agent A and buyers is closing with closing agent B, it might be a different document. So again, our thought is the affidavit is going to be generated by the closing agent in this interim period of time. While FREC has not yet created the affidavit, there's going to be some variance. But again, we are thinking the document is coming at time of purchase, which the way we are analyzing is when the buyer pays for the property and when the buyer takes title, because this law is about ownership and acquisition. So this is how we're looking at it. I think that covers, no, I think there's maybe one more slide, Joanna, I can't remember, just advance and we'll see. So from my perspective, we have talked about the revisions to those 5 sale contracts. We've talked about the language, we've talked about where it is. And the one thing I did want to mention is when the committee placed this language above the signature in hopes that it would really draw the attention of the parties, the thought was ultimately when this is no longer a brand new law, the language may get moved. It may move into paragraph 10, which is the disclosure language. It may move into paragraph 1, which is the language about the parties. It may move into closing documents in the standard I. We don't know, but I just wanted you to let you know right now this is where it is, and that's why it's there. It may not stay there forever. We also covered the addendum to contract, which is brand new. You can give it to parties if they're already under contract, or you can use it if you're using a form that we haven't discussed. We've also talked about the affidavit the buyer must provide at time of purchase. Lastly, Joanna has covered a law update, trying to give you the highlights of the new law so you have a general understanding of this conveyance to foreign entities law.
So thank you, Marcia. And just a quick note, obviously we are going to go past an hour, but we're going to keep going. We're respectful of your time, but we want to make sure we cover all of this information. So we appreciate you bearing with us for another few minutes. Because now let's talk about the challenges, right? This is what many of you want to hear about. Can I just be honest with you and tell you that there is a concern about fair housing and how you handle this transaction, which is why we cannot emphasize enough that because this is an unsettled area of the law, because we have at least a number of folks, including the Department of Justice, weighing in on the fair housing concerns here, we want you to stay away from trying to assess proximities and direct or indirect or de minimis ownership and all of these things. This is the party's responsibility. Determining the location of the military institution, so that, we talked a lot about the buyer, but let's talk about, when you are listing a property, determining the location of military institutions or facilities of concern, that is not something that is going to be readily apparent to even perhaps the seller of the property. And so I cannot emphasize enough the fact that you do not want to, go to MapQuest trying to figure out how close this is to, the covered facilities. This is not something that we want you to do. That is a challenge. Hopefully at some point there will be a list or some resource available to help sellers understand, comprehensively where these facilities are. We don't presently have that. But please do not undertake that responsibility. Buyers will be able to provide at the time of purchase, closing likely, an affidavit established by FREC. But unfortunately, that has not yet been created. The industry has filled the gap. And there is this affidavit floating around, but I don't know if Marcia mentioned, we got 2 copies sent to us from members yesterday. One of the copies that we received is the same as what the Florida Land Title Association helped draft. The other that we got from the member, whoever they got it from, had made alterations to that form. Why is that important? Because if you get into the habit, which we cannot emphasize enough, that you should not be in the affidavit space. Don't get into the habit of providing affidavits. It is very possible that the affidavit that you give the buyer trying to be helpful may not be the same affidavit that the buyer sees when they get to the closing table, okay? Because closing agents may create their own affidavit, is my point. The registration process is not yet in place. That's a challenge. Folks are probably going to ask you, do I have to register my property? Yes. Where do I register? Well, we don't know. So that's a concern. The other thing I will say here is we said in 2 of those instances that the parties have to register with the Department of Economic Opportunity. There was another piece of legislation passed that will change the name of the Department of Economic Opportunity to the Department of Commerce. So it is very possible that your customers, when they come to you and say, Joanna, I'm trying to, come to you and say, I'm trying to find the Department of Economic Opportunity, but I'm seeing something instead that says the Department of Commerce. That is going to happen after January 1st. The terms of the law are unclear. This is an unsettled area. What is meant by domiciled? I saw a question in the chat that says, well, what if they have, 2 homes, one in Italy and one in, China? then according to the law, it goes by where they're domiciled, but it does not define domiciled for us. So be very careful with that. They need to talk to their attorney about that. Violations of the law are crimes. This is why we don't want you making representations that they may rely on. They can lose their property. We don't want them losing their property and blaming you because you weighed in on whether registration is required or not. So we're waiting on these rules. We will keep you informed, but be the source of the source. These are legally driven concepts: visa, diplomatic status, asylum, fair housing, de minimis ownership. These are very, legally driven concepts. So stay out of the process of making representations. I know that's hard. I know they ask you all the questions because you call us and you tell us they're asking you, but you cannot own these representations. So here's some practical advice. Treat every buyer the same. Every buyer the same. This is why closing agents are not going to give the affidavit to people who they think might be domiciled in a country of foreign concern. Everybody is going to get the affidavit. Why? Because they're treating everybody the same. That minimizes any argument, minimizes the argument that you're violating fair housing here. So it's important to be consistent. You're going to give out documents, if you're going to, we don't recommend you giving out affidavits. We want you to stay away from that. But whatever it is you decide to do within your office, treat every buyer the same. Continue as usual to work with all buyers, This is not I'm not sure I want to deal with foreign transactions or transactions involving it. Every single, you work with all buyers equally. So we give professional services regardless of where that person is domiciled. Ensure that it is neither your intent to discriminate. Make sure they understand that you're trying to comply with state law. Don't ask them questions about their national origin. Document conversations. Document how it came up. If they ask you, am I able to buy? I'm domiciled in China. Tell them they're going to need to speak to their attorney. Don't ask them questions about where they're from or those things, because remember, even if you're not intending to discriminate, there's always the possibility that it could be perceived as disparate impact. Make sure that you state the purpose of the discussion is for complying with law if they do ask you questions. Do not attempt to explain the law or give legal advice. Refrain from possibly, trying to calculate the proximity of the property to these military institutions or areas of critical infrastructure. If you get that calculation wrong, it might be considered, it might expose you to liability. And additionally, if you get it wrong and you say that it is within the radius that prohibits buyers from the foreign countries of concern, and it turns out that it is not within that radius, a buyer may feel that that's pretext, right? You're using that as an excuse to not sell to me. Stay out of the affidavit game. Let the closing agent provide that information. And here's the thing, y'all. We've talked a lot about fair housing. We embrace it, we promote it, and we educate on it. And we all know that testing is a legitimate concept within the fair housing compliance world. So don't be surprised if you see testers that come about as a result of this. Make sure you are, as we say, prepared to answer the questions properly. In this case, if you're concerned whether or not this applies to you, you must see your lawyer. So a few more practical considerations. What do you do if the buyer says that they are associated with a country of concern? They walk into your office and they explain that to you. And you say, okay, remember, you're going to work with everybody. But here's the thing. They need to speak to their legal counsel. And why is that? Because you're not in a position to provide legal advice to them on these complicated legal issues. Maybe they are a foreign principal. Maybe they are not. Maybe the property is or is not one of the covered properties. But you don't want to put yourself in a position of making that ultimate determination. The parties need to make it and need to inform you of their status. They can make it alone or with the advice of counsel, but you don't make that determination. Ultimately, the buyer is at risk if they don't meet the requirements of the law, and could face some pretty severe penalties. And so could a seller who knowingly participates in the sale of a property. Now, a few what ifs. What if the buyer explicitly says they are covered by the statute, they are a foreign principal, and they still want to purchase property in violation of the law? Now, I said we want to work with everybody, right? We don't want to deny professional services, but this is kind of akin to when you all call and you say, the seller is telling me I can't disclose that there's roof damage, that there's a latent defect, that there's something else, and they're insisting I cannot do that. What do I do, Joanna, if they're asking me to possibly expose myself to violating the law? Well, you might want to consider withdrawing. If the purpose of your withdrawal is not because of their national origin, not even because they say, they're domiciled somewhere, but it is because they have informed you that they are legally prohibited from conducting this transaction and they are insisting on moving forward anyway. That may not be a buyer that you want to work with, because you don't want to aid and abet criminal conduct, and you certainly don't want to find yourself liable. But you need to document, because ultimately a court is going to have to determine the appropriateness of all of this and how this conduct, how that conduct would be viewed. Now, if the buyer is a foreign principal, what if the buyer is a foreign principal who is purchasing property, but it's not in violation of the law? So they've said to you, listen, I went and I spoke to my attorney. The attorney determined that I qualify for one of the exemptions, so I'm not prohibited. Should you withdraw? Probably not, because if the buyer relies on the advice of their counsel and they are not in violation, they may be domiciled in one of those countries, but they check all the boxes for an exemption, then you don't want to deny someone who's otherwise qualified professional services. But you have to document, okay? Why would you still work with them? Remember, the law does change. It ultimately changes who can own property, but it does not ultimately dramatically change the way you handle a transaction. So if a buyer says, this doesn't apply to me, my attorney said, document. What have we heard on the hotline? We've heard some very interesting questions. Is there a complete ban? If someone is associated with a foreign country, is there a foreign country of concern? Is there a complete ban? No, it is a very nuanced law. So no, there is no complete ban. How do you determine whether a buyer has a de minimis ownership interest? You don't. Although we included slides that kind of give you the basic parameters of this, you are not to review their ownership interest. This will happen a lot with commercial. This will probably happen with vacant lands and things like that. You do not want to go in there trying to determine their ownership interest and where there's a subsidiary and where there's not, okay? That is not your responsibility. Where to direct current foreign principals who own these covered properties. Registration does not yet exist. Stay tuned. They need to check the law, not just for Department of Agriculture and Consumer Services, but also the Department of Economic Opportunity, which will soon become the Department of Commerce. What if the buyer was in compliance with the law at the time of purchase, but their visa expires after closing? The law does not address this scenario. This is why we say it is unsettled, okay? There are some critical issues of timing here. It is possible that a buyer is not qualified to purchase today, the day they make the offer, but they ultimately become qualified due to some intervening circumstance. Maybe their domicile changes, whatever the case may be. The issue is, this is why they are making the representations about their status at closing, because it may change during the pendency of the contract itself. Now, Talked a lot about buyers. What about the seller? What do we tell them? Same as with the buyers. You can make them aware of the law, but if the seller wants to market their property and they are within that 5-mile radius or 10-mile radius, then they need to understand that this will impact them. How? They have to talk to their lawyer about that. But make sure they understand if it impacts them, fine, but they want to guard against any appearances of pretext by saying it does when it may not. If you are listing properties, it is very common to say things in the multiple listing service like close proximity to airports, close proximity to NAS Pensacola. Be careful with these now. This is calculated risk area. If you make these kind of representations, it may be perceived as you're sending the message to people of foreign countries from applying or for making offers. But for all, please, by all means, do not put in your advertisements, not available to people from these countries, okay? That is not a representation you want to make. Make sure that you are, again, the source of the information. I'll move on quickly because we're running out of time. Will buyers' deposit be forfeited if they can't sign the affidavit at closing? We don't know. Again, this might be a new area of cancellation of contract for people. And so it is going to be a factually driven determination that a court will ultimately decide. If I know the buyer is in violation, we've already talked about that. You probably would be facing liability. So be very careful with knowingly helping buyers to violate the law. That's not a role for you to play. Now, where do we go from here? Because you're probably sitting there and you're thinking, well, you know what, let me answer one other question that we get before, and I saw it in the chat, and this is why I want to answer this. What about contracts that are currently, under contract? It's a developer contract or some of the contract that takes a long time, and the person was qualified to buy on the date of the contract, but they're not qualified to buy because they can't close until August. The property will not be built until August. Here's the deal. Again, unsettled area of the law. But what we do know is that they are very likely going to be handed an affidavit in August when the closing comes around. And if they cannot sign that affidavit, they would be taking property in violation of Florida law. What's going to happen with their deposit? We don't know. One of the things I've been suggesting is perhaps the parties need to discuss assignability of the contract. Can the contract be assigned to someone who is qualified to purchase, right? So that is one potential vehicle to try to get the property to closing so that, someone can take title to the property who does not violate this law. Now, road ahead. I know we didn't answer all your questions today. That is hard for me to say. I know we didn't alleviate all your concerns today. That is hard for me to say. Every single day we are engaged with folks on this issue. We will continue to be engaged with folks on this issue. We will keep you informed as the Florida Real Estate Commission works on the affidavit and the rules. We will keep you informed as the agencies establish these registration processes. I commit to keeping you informed if the forms committee determines that perhaps there are new forms or new revisions to existing forms that are needed to assist with complying with this law. That's not off the table. We'll keep you informed. We will keep you informed on the court rulings, the agency orders, or any other opinions from anybody, the court's decisions. We will keep you informed on that subject. So in other words, stay tuned. This is an evolving topic. Couple of resources I want to give you in case you haven't seen them. You've already seen the contract. This is a snapshot of the conveyances to foreign buyer addendum that can be used as a standalone to be incorporated in a contract. Maybe you have another version of the contract that you're already working with. We also put together a memorandum for your use that covers all the different sections. The buckets these are the buckets, as we call them, in these colored blocks on this form. Section 5, Section 6, Section 7. There's also a flow chart that is a more easily digestible kind of document that covers those categories I talked to you about: purchase, sale, ownership, other acquisition, devise, descent, inheritance, those types of things. So there's a flow chart to help you with multiple pages, one for each of our buckets, our categories, to help you understand. Now, I want to thank you all for attending today. I apologize that we went over, but we wanted to make sure that we got this all to you. Just remember, for the most part, you will proceed with these transactions after July 1st the way you currently do. I know that's hard to conceptualize, but remember, we're talking about the tactical ways that you handle these matters for your customers. We recognize that it has just gotten a bit more complicated for you all with this. We get that. We certainly recognize that it is more complicated for the buyers and sellers, but unfortunately, this is a time where you don't want to be the source of the source. You want to send them to their counsel. You want to send them to folks who can answer these questions for you, because remember, the penalties are stiff: forfeiture, lien, fines, and even criminal sanctions. Please do not assume the responsibility of making these determinations. As always, call us if you have questions. Call us on the hotline, 407-438-1409. Can we tell you whether or not your buyer or seller is impacted by this law? No, we cannot. But what we certainly can do is walk you through some of the, particularly the liability and issues, the exposure that you all may have as you tactically go through this transaction after July 1st. So with that, I want to thank you all. We have your questions. There are some excellent questions in the chat. I took a peek. We will develop future resources to help you with the answers to some of those more specific questions. We thank you and we appreciate everything that you are doing. Thank you for your patience and your understanding as we continue to navigate these very difficult waters. Have a fantastic day, everyone.